Insurers and Reinsurers. Get to know the main points of attention with the publication of the new PGFN Ordinance 2044, which comes into effect on March 1st, 2025, and replaces Ordinance PGFN 164 that has been in effect for 10 years. March 1st, 2025, and replaces Ordinance PGFN 164 that has been in effect for 10 years. Our guests today are the renowned Paixão, a legal manager of insurance at Pottencial, an insurer that has been leading the surety insurance market for the past 7 years. With 15 years of experience in the market, Pottencial was founded with the mission to simplify and automate the surety insurance issuance process in the country, as well as to support its partners throughout the entire journey. Lawyer, member of the Credit and Guarantee Commission of FEMSEG, postgraduate in Civil Procedural Law from the Fundação Mineira de Educação e Cultura, with an MBA extension course in insurance, including surety insurance from the Business and Insurance School, leadership training from Fundação Dom Cabral, and strategic management from INSPER. Rafaela Ramalho, legal manager at Junto, the most traditional insurer in the surety insurance segment, which has led the market for the past 3 decades and has played a key role in dialogue with public insured parties through the presidency of the Surety Insurance Technical Commission of FEMSEG over the last 10 years. This year, Junto is also celebrating 30 years since the issuance of its first surety insurance policy. Rafaela graduated in law from Curitiba and has nearly a decade of experience in the surety insurance market. Cássio Amaral, a lawyer and partner at the law firm Machado Meyer Advogados. Cássio is one of the leading references in surety insurance in Brazil, holding a law degree from the Federal University of Bahia, a master's in administration from the Federal University of Bahia, a master of laws from Emilion Business School, and is a qualified lawyer in Portugal, the United Kingdom, and Brazil. Currently pursuing a PhD in Business and Innovation at GV. Thank you for being here. The new ordinance introduced several aspects, some favorable, others that are points of attention that insurers and reinsurers need to observe. One of them, which is quite positive, is the issue of clarity, the non-renewal. Up to this procedural ease, right? The issue of the 90 days was quite confusing. Then having the return from the policyholder to be able to proceed and attach the policy, issue the policy up to 60 days, which was provided for in PGFN 164. How have you seen this from the insurer's point of view?
The operational point of view is positive. We have 2 important points there. The 5-year term, obviously for insurers, reduces a bit of the operational renewal process, but the part of updating, which is the monitoring of the value throughout the process, the ordinance benefits us by stating that the renewal is automatic, independent of authorization. There was a discussion about this point, whether the insurer can simply issue and then charge the premium. Now it's clear it can and should be done because the policy must keep up with the evolution of the risk, because eventually it doesn't start after 5 years. The value will be different from what was initially stated in the policy. It's also important from an operational standpoint for us to evaluate how this transition will be made, right, Rafa, at the moment of this change as we are moving from one ordinance to another. And the insurance companies are preparing for this. Systemically, we say it's not the lawyer who works in this area, but systemically we have this challenge of also having the client understand and request correctly, but we need to know how to guide them. Today, how does the ordinance bring this moment to us? Risks are already in effect. So the policy is already issued under 164 and all good. 4 is all good. Update then, value tracking, same rule. We only do the update through the existing product, which is 64.
And these endorsements don't even need to be attached to the process, so they don't even reach the knowledge of the PGF.
Yes, renewal. Renewal is already under the new product, so we have to make the endorsement or issue a new policy, but already under the new rule, already with 5 years. Maybe there might even be a reduction due to the 30% anyway. But we are preparing for this from an operational standpoint. I think that insurers as a whole, across all sectors, are going through several changes. And this is another one that we will also adapt to, and it is part of the market's evolution process.
And Anna, there's also an important point, which is that although the ordinance no longer requires us to renew 60 days in advance and allows this to happen until the end of the policy's term, it also mandates that insurers start the renewal procedures 90 days in advance. So insurers will end up having to meet this deadline to initiate the renewal processes to ensure we have enough time to deliver the policy to the policyholders, for them to present the policy in the process or to express themselves in the process for a possible substitution if necessary.
Perfect. And there was even some doubt about what it means to start the renewal procedures. So what is that then? Sending the proposal, already sending the draft to the broker so that he can go to the client and say it needs to be renewed, maybe. Even do it all at once for this renewal to avoid leaving it until the last minute on the expiration day to renew. And also from an operational standpoint, it brings a moment of maturity for insurers. Before, we had the mindset that if it wasn't renewed by the end of the term, I would explain to the legal department that there was no harm, that the process was guaranteed regardless of the renewal and everything else. But they say that retroactive coverage is not acceptable. There's no way to fix the mistake. After the milk is spilled, there's nothing more to be done. And insurers do need to evolve. In this regard, taking care to start the process, giving the client a chance to prepare for this gathering, not doing anything at the last minute, and not thinking that failing to follow this procedure won't have any consequences, because now it will. It's clear.
It's the increase in diligence, right? Previously, the insurer had confidence in the product, that the process was already guaranteed, regardless of the policy renewal. And then it became a bit less demanding, diligent in its internal processes, in the presentation of the renewal, due to the understanding of the product. Now the PGFN is coming in more strictly and bringing a very significant consequence for insurers, which is the characterization of a claim if it is not renewed. And this aspect leads the insurer to revisit its processes. And speaking from the reinsurer's point of view, I think it goes a little further in the underwriting process. When we talk about underwriting proportional contracts, which make up the vast majority of reinsurance market contracts, there is already an underwriting policy in place. You underwrite the company, so you already approach the company on various aspects. Typically, you address the technical capacity of underwriting, the technical capacity of claims, but an important aspect that needs to be observed now, which can bring claims to the reinsurer's portfolio, is the insurer's diligence in monitoring and following up on the process to ensure no deadlines are missed in presenting a policy at the time of renewal.
Perfect. We talk a lot, and I think the message from the legal department is to review your processes. So we need to have processes that truly align with what our policyholders demand. And speaking of processes, we have changes in processes across various areas. When we think about claims, for example, the reinsurer needs to look at this. What is the consequence of not paying a claim on time? From the moment the legal department summons us, and this can be done by them, as we mentioned here, it will provide more speed, and now the attorney doesn't have to wait for a judicial act. They can anticipate and expedite the process themselves, sending the documentation within 15 days. And then if we request a document, we have 15 days to request it, and when it returns, there is a suspension of the deadline, and we will have the complimentary price.
When the document is relevant, it needs to be justifiable. But I think a very positive point was the list of documents that will be presented to be able to notify the claim. And this also provides an assurance that the payment is being made at the value that settles what was expected by the PGFN. The documents are listed and clear, and they are objective. So it also brings fewer doubts Yeah. I think it is not expected to have back and forth in the requirement, in the request for additional documents at the time of claim adjustment.
The attorney's office is spread throughout Brazil, so it brings a homogeneous function for the attorney to act as well. He knows what he has to send, and the insurer knows what it has to receive and how many days it has to pay. If it wasn't done, meaning there isn't a well-defined control process, then there will be a consequence, as we mentioned.
And then, Anna, I think there's a very important point to mention for the reinsurers, which is that before, under PGFN 164, the major consequence was for the insurer, which could be placed as a defendant in the execution, could have a record in CADIN, and a series of consequences. But now the non-payment of the indemnity can bring consequences for the reinsurer. Why? Because if the insurer is prevented from doing so, and any irregularity can prevent it from issuing new policies for PGFN for 180 days, this can cause other policies from that insurer to lapse due to the lack of guarantee replacement by the policyholder at the time of renewal.
Because from that moment on, the clients may become apprehensive and even anticipate this replacement.
And besides the cross effect, the cross contamination, where one co-insurer can contaminate another in the case of co-insurance. So I think former insurers, as general insurers, need to pay attention as well who their partners are.
Exactly.
And this is also important with regard to the role of the leader. The regulation introduces the figure of the leader with an operational role.
The co-insurer is the leader, right?
Against the lead insurer, the relevant operational role. But above all, with the new legal framework for insurance, the lead insurer has other roles, including procedural ones such as procedural substitute in the event of policy activation. So eventually, if the claim is not paid, only the leader can be executed. Of course, it will continue to be not jointly liable, but only against the leader. And the leader will respond on behalf of the others. So the role of the leader, the co-insurance contracts, not only for surety insurance, but in all other lines of business, must be revisited.
In this case, Cássio, a question. All despite the leading co-insurer being the representative and the one who will be at the forefront. I imagine that all the co-insurers will also be placed on the restricted list of the PGFN for 180 days. So this will not be exclusive to the one managing the process. Eventually, the lack of diligence by the leading co-insurer can bring consequences for the co-insurers.
The possession is unique. The possession is a co-insurance. Perhaps the co-insurer that does not want to harm itself to avoid being harmed is an alternative that the insurer can have. Because here, if it gets tied to the default or inadequacy of the leading insurer or the other co-insurer, it will harm itself. So eventually it will have a judicial measure. It will say, look, sorry, I am not jointly responsible. Here is a new policy or possibly a deposit. We will see how that will happen. Hopefully it doesn't happen that the market and partners act in unison. But if it does happen, I think the leading co-insurer has a significant role and the others might have measures to be able to remove individual responsibility.
And this measure goes very much in line with the need to review the co-insurance contract. The co-insurance contract today establishes, for example, the obligation of the leader to inform the other co-insurers about a claim notice. These deadlines will have to be reviewed. The payment deadlines, as there is no joint liability as a rule, each one does their own. So none of them can miss this deadline, but for that, the leader must be diligent in communication in managing the claims process, which is usually conducted by the leader. It's that partnership thing, where the reinsurer also needs to have this perspective to see with whom the insurer they have a relationship is closing deals.
I find it interesting, Anna, because an interesting aspect that can be included in the reinsurer's underwriting process is, in fact, who are the co-insurers that the insurer they are protecting has partnerships with due to the consequences this can have for the portfolio.
And there's another point. We talk a lot about claims when we discuss judicial policies, but the attorney's office introduces the concept of expectation, which is very common in contractual surety insurance, but not in judicial ones. But for administrative negotiation, we have the concept of claim expectation. But it's not the PGFN that will notify, they will make it available. And again, insurers can monitor this risk, and they will need to have well-established processes for this, if that is the company's interest.
Which is the diligence we rely on. Yes, we used to do an indexing to understand from that relationship who is in your client base.
Of clients to cross-reference that and already anticipate any potential claim with a well-structured CCG. This is also possible. Counter guarantee contract.
But operationally, the PGFN also brings positive points from the perspective of claims. Today, with the 164, we still do receive notifications that are prior to the insured's own notification. And the PGFN 2044 now brings not only the list, and it is very beneficial that it provides the list of documents that need to be presented, even if the notification is made by the PGFN itself, to provide the updated debt amount that insurers need to pay, which makes it easier. And because often we need to understand what amount needs to be paid there. But it also brings this point that it is after the borrower's notification, if they do not make the payment, then the insurer is notified and informed for payment, which will also facilitate the issue of the updated amount already being presented by the PGFN itself. This is one of the points that might help insurers mitigate the risk of not making the full debt payment, which is a very serious consequence of being prevented from issuing new policies for 180 days. So this also operationally aligns in a beneficial way for the insurers.
And we covered the main points of attention that insurers and reinsurers will focus on with the publication and coming into effect. On March 1st, 2025, of the new PGFN Ordinance 2044, 5 of the new PGFN Ordinance 1044,